This is what helps you when you are facing a zombie debt foreclosure, whether in the judicial state or in non-judicial foreclosure statute. You have legal weapons under the FDCPA, TILA, RESPA, and your state law. I've read a lot on this. People just they just go, oh God, it is my house, don't want to lose my house. They bring the emotion into it. And a little bit of reading means a lot of protection. So the first thing I want you to do, the minute you know someone's coming after you, use my kit attached to Killdebt.com. Please, action cures fear. Just step up. Actually, the fear goes away once you do step up. Just trust me on that. Be scared for 5 minutes, then make a move. The first move you make, the toughest move, is the toughest move. And once you make that, you send a letter saying, hey, I don't know this, prove you own it. You will feel better. Please, action cures fear. Take the emotion out of it. The same thing happened in California. Essentially what they're just saying is, hey, debt buyer, prove you own the debt and the chain of title, and you have the right to pursue the amount that you seek. Hey, Brian Parker here with another exciting video. This next video is from another video I just did that got so many views, so many for me, a lot for me. And I thought, wow, I really touched on something here. I've got to do another video. And interestingly, commenters were asking me, yeah, that's great, thank you, non-judicial versus judicial, and we'll get into that very briefly again. But what about second notes or HELOCs? And also there is a tsunami now, as I'll explain, of dead notes or zombie notes that are resurrecting. One article I read called them ghost notes. So we're going to look at the next connection to the zombie tsunami that is here and show how 600,000 second notes or HELOCs are out there that are now coming and resurrecting from being dead. And 10, 15 years later, after these things went away, homeowners are now being sued and facing losing their house and losing their homes because something that should be long gone. And we're going to show you how that happens and how to get out of a situation. When I first started reading about this, and I've done a couple of videos on this, let me just put those up there, zombie debt. They didn't get much of a reception. I think this will. And I remember being very angry because I've done everything you could possibly do in the debt collection world as far as either suing or mostly I do debt defense. And back in the day, 2008 to 2012, I did an enormous amount of debt foreclosure defense, keeping people in their houses. So I know a thing or two. It's interesting because at the time, if a house went to a short sale or we got people out so they weren't owing anybody anything, I'd always scratch my head and go, there's a second note. What's happening with that? Is it just going to go away? And in some cases it did. It got waived either through a mortgage settlement that a lot of the states did with the mortgage companies where they got hundreds of $millions and it's supposed to have dripped down to homeowners. And in some cases, people's debt were waived, especially second notes. And again, I always say, so where's this going? Eventually something has to be paid here. Well, it's happening now. All those notes that were just buried or waived are now being used just like the same concept as old debt buyers that take old notes they can't prove and sue people for everything, even beyond statute of limitations or the legal rights to do so. That's happening now with the second note. So I read 3 articles, a Bloomberg.com article, an Independent.co, which is a UK article doing, it's so on fire over here that this UK company, this paper is doing articles on the US explosion in mortgage notes, and also The Sun, which is also a UK company. So I relied a lot on Bloomberg and a little NPR, CFPB, and I want to remind you this is for educational purposes, but the education is mine. This is 33 years of dealing with what this really is. Bottom line is just a debt buyer trying to resurrect an old debt and sue you for the whole thing after they paid literally pennies on the dollar. I want to say also I have a new channel out there. Has nothing to do with my debt defense, but you may want to check it out. It's called What's It Like? And what I do is I interview people with interesting stories. For example, we just did one, What's It Like to be a Mentalist? And we did a great article. You might want to see that. A lady just climbed Mount Kilimanjaro. So the name of the interview was What's It Like to Climb Mount Kilimanjaro? So there'll be many more on the horizon. So check out my new channel. I'll give you a link. And also it'll be on the bottom of this video. But as I said before, that video 2 days ago, let's put it up there, has just exploded. And people are asking, what do I do with second notes? So we're going to talk about today second notes, zombie foreclosures, the dead debt that wakes up to eat your equity, if you will. So there's tons of ways to handle this stuff. But you got to remember, your house is tied into your emotional well-being. It's that foreclosure crisis. I saw a lot of emotion. It was all emotional and hand-wringing and crying, and it was the American dream to own a house. I think ended back in the foreclosure crisis, and it was now a financial situation. But we applied our emotional needs and responses to a transaction situation to our detriment. So I want to hope that this video today takes out the emotion for you, and you'll see how. So I have attached to this video a zombie foreclosure defense kit. Let me just give you a picture of the number of letters that I instruct you, if you want, you be you, to use once you know that foreclosure, even with the debt buy. It's just a debt buy at the end of the day. But what it is they buy your note, your second note, and foreclose on the house, which, as I said in that last video, there are two kinds of states. There's the judicial state and the non-judicial state. If you're in a judicial state, for example, like Florida, then you have all the rights and defenses of the FDCPA and your state acts, and they've got to go through a judge. If you're in a non-judicial state, then you really can't use a lawyer unless post-foreclosure you discover they did something wrong. Or, more importantly, under the FDCPA, I think it's 1692 F6, which says the debt buyer or even the creditor that's seeking to foreclose on your home in a non-foreclosure state, they must pass through certain burdens to be able to have the right to pursue you. And while you don't have a judge involved in a non-judicial statute state, you can file a TRO or bring a judge in to say, hey, they haven't met 1692 F6. But with the judicial state, a judge is always there. So we're going to break down the ways that you can help yourself when you're losing your home or you're being pursued for a note, because it's all about debt buyers really, in a zombie mortgage debt situation. So a zombie mortgage, let's put it up, a second mortgage or a HELOC that a homeowner stopped hearing about years ago and believed was resolved, forgiven, or discharged in a bankruptcy. It isn't. It just went quiet. And now, like a bad zombie movie, it's back. One of the articles I read from The Sun said there's what's called a ghost mortgage, Shazam. The Sun defines a ghost mortgage as a form of zombie debt, a debt you've already paid off, a debt too old to legally collect. Key on that, by the way, statute of limitations. Or a debt that belongs to someone else entirely. That case I did in that video, the foreclosure video, Tsunami, Mr. Robinson, it was clear to me that they were chasing the wrong person. He got the loan, I think, in 2006, and yet they had bank statements where he failed to make payments 39 years prior to when he even took out the loan. So I think that was a case of an ID theft or a mistaken identity. Either way, he should win. So here's the different phases that got us here today. Number one, phase one, more than 9 million second mortgages. So if you remember back in the day, it was easy peasy to get a mortgage, and then you got a second mortgage to pay off some bills, or even with the no doc land, you could just take the second mortgage to make a down payment on the first mortgage. It was quite circular. And that was between 2004 and 2008. Of course, 2008 to 2012, where I did most of my work, heartbreaking, wanting to jump a bridge off at the end of the day type of work, that they came after me with so many cases where they just voluntarily decided, hey, nope, bank wins, when no one asked the Court of Appeals to do that. I said I'd had it. I just reached my wit's end, and I'd use the FDCP and everything. That was the crash. Sorry to go on and on. And then phase 3, the long wait. This is 12 to 20, where the zombie debt, the second notes, were all buried. And then phase 4, and I use this word, the resurrection, 2020 to the present, home prices soared after the pandemic. So what happens is, it took a while from 2008 for home values to go up, and go up they did. And that affected me personally in that home equity went through the roof, especially after the pandemic. So now a $200,000 house is worth $350,000. And how it affected me is I have clients that unfortunately were claiming poverty successfully and enabling me to get them out of debt, even credited debt, for pennies on the dollar. Then I started to notice that debt collectors and their attorneys, law firms, would say, well, wait a minute, she has this house and it's got $100,000 in equity, which it didn't have, a year or two before that. And because of the housing explosions, I was having a harder time to show my clients were in poverty. Because they had a house that wasn't worth anything, it suddenly became a ton of equity. And even bankruptcy trustees looked at that as cash and were turning very applicable bankruptcy people that could have declared bankruptcy 2 years earlier. Now they were considered as very cash. They had a cash surplus because of that home equity. And so the zombies woke up. So as the equity and home prices rose, so did the zombie debt. And the letters start arriving. You start getting debt. You've forgot about this and don't remember the second note or HELOC that you took out, but the letters came. And at that start at 220 is where we are today. There's 600,000 HELOCs out there, zombie debt, that are now being resurrected. So I talked about how home equity has made you more vulnerable. The inability to go through bankruptcy or to settle your debt for as good as one could. It's also made people subject to fly-by-night or horrible debt collectors that bought your debt for pennies on the dollar 10 years ago, and now they're coming after you. So let me show you the debt collector home mortgage HELOC zombie debt model, okay? Step 1, the bank sells your debt for almost nothing. After the crash, 2008, 2012, Bank of America, Citigroup, JP Morgan, Wells Fargo, Chase were sitting on roughly $475 billion in second mortgage note, had no value to them. The houses have been sold off or waived in those mortgage settlements. So they sold the debt on the secondary market, often for pennies on a dollar, just like any other debt. The debt collectors, debt buyers saw the model from day one. They saw the securitization model, and they saw the model of what the banks were doing with debt they couldn't collect upon. So the debt buyer just sat there and waited, and in its head, the interest rose, the value of their purchase rose, and there are ways around that, as I'm going to show you. The bill arrived on stage, step 3, with years of interest, mostly that the debt buyer can't prove or follow the law to show or prove it. And then you are in a world of hurt, because now, as I talked about emotions, the fear of losing your home now from what's on its surface looks like either a legitimate judicial foreclosure or a legitimate non-judicial foreclosure. What bothers me the most is the non-judicial foreclosure doesn't have a judge reviewing it. So this fly-by-night company or this debt buying company that bought this very old debt and is now coming after you in a state where there's no judge because it's a non-judicial state, it makes it even harder for you. So out of fear, many homeowners make a deal with this company 15 years later, even if the debt is time barred. You can imagine when I talk to you about debts being 10 or 15 years old, they're probably time barred. So let me first put up the statute of limitations in states and how many years under mortgages they have to pursue you. Shazam, whether it's a non-judicial or judicial state. Keep in mind, Maryland and Alabama currently do not have One's very red, one's very blue, so I'm not pointing fingers. Those two states don't have an SOL or a statute of limitations where the debt and the ability to sue on it are now dead. That's very interesting to me and scary to you. So what we want to look at is, while if you're in a non-judicial state and you're facing one of these HELOC or zombie mortgages, it's a tough ride, but there's many options for you. So the states are seeing what is happening. So normally the CFPB will make a rule in this regard to protect people on a national level, because this is something that's happening on a national level. It's been gutted and underfunded, so it has no teeth and no ability to protect you. So some states are now coming out of the woodwork. California, let me put that up for you. Servicer, that's the debt buyer, must, and I've read a lot on this. People just don't even, they just go, oh God, it is my house, don't want to lose my house. They bring the emotion into it. And a little bit of reading means a lot of protection. So the first thing I want you to do, the minute you know someone's coming after you, use my kit attached to Killdebt.com. I want to tell you quickly about Virginia, Shazam. Virginia is proof of the concept that works. After Virginia passed the 2024 law requiring debt collectors to sign legal documents, what's wrong with that if you're telling the truth? Attesting to the back interest amount was accurate before foreclosing. Zombie foreclosures in Virginia essentially stopped for a full year. So that is a good thing. If you want to push your legislatures for zombie law protection, there's a great role model for you. The same thing happened in California. Essentially what they're just saying is, hey, debt buyer, prove you own the debt and the chain of title, and you have the right to pursue the amount that you seek. I've done videos on that. We'll move on from that because these scoundrels, these bad guys. But this is what helps you when you are facing a zombie debt foreclosure, whether in the judicial state or in non-judicial foreclosure statute. You have legal weapons under the FDCPA, TILA, RESPA, and your state law. So let's put up a couple. Shazam, 1692F6. All states post Obdusky. So my last videos, put it up there again, I talked about the Supreme Court and Obdusky made it that anybody that sues you in a non-judicial foreclosure statute is not considered an FDCPA regulated entity, so they don't have to follow the law under the FDCPA, but they have to follow 1692F6 to prove that a valid enforceable security interest exists. And unfortunately, again, in a non-judicial state, there's no judge, so you've got to do a TRO or file a wrongful foreclosure statute. By the way, wrongful foreclosure claim. Wrongful foreclosure lawsuits are never barred either by Obdusky or anywhere else. If you've been wrongfully foreclosed upon, you have the right to sue the people that did that. You just can't do it within the non-judicial statute foreclosure. But there's ways around that. So we move on. In judicial states, you can use FDCPA 1692E, prohibits false and deceptive representation. Collecting interest for periods where no statement was sent qualifies. That's in judicial states. 1692G, in a judicial state, they must send you a letter telling you have 30 days to ask and dispute their claim that they own the debt and that you owe a certain amount. TILA, very important. If a servicer, so these debt buyers are now going to claim that they're now servicing the debt and now they want their money. If a servicer failed to send you periodic statements for years, this is a TILA violation that can challenge the accumulated interest claimed and will or may block foreclosures. In all states, you can use RESPA, which is a qualified written request, forces the servicer to produce a full loan history. So what's significant about those two things, about answering their belief that they're servicers and now they want a bunch of money? Those are two great ways to make them prove it. And it is, as you know from, I've literally done hundreds of videos. They can claim that you owe them something, but a debt buyer buying something pennies on a dollar, and as I said in phase 2, The bank sold them these debts and all the ability to prove it 10 or 15 years ago, and that stuff has gone by the wayside. So this zombie foreclosure defense kit I've got, let me put up that first page again with all those letters. Soon as you hear that's coming your way, that's the letter you need to send out. It's attached to killdebt.com, and it's embedded, as all my videos, my 700 videos are. The transcripts are embedded in Parker GPT. Statute of limitations. If a debt is barred, time barred, foreclosure threat may be illegal. So we're going to foreclose if you don't pay us $78,000. That's an illegal statement, because if the statute of limitations passed, you can't legally pursue someone. So check your state. Now let me put that up again, all the states. Shazam, that's a list of all the states and their statute of limitations. So just a threat gives you an ability to push them back. And debt collectors live and die and are resurrected and breathe again on threats. It's an emotional reaction. Whenever you're threatened financially, reputationally, or just somebody physically wants to threaten you, you react emotionally. Your adrenaline goes up. You don't make good decisions. Well, keep emotion out of it, please. There's a equitable, if I remember from law school, there's an equitable claim called latches. Shazam. Oh, yeah, it says equitable defense. I do use that in my classes. All states, courts can ban a foreclosure even before the statute of limitation expires if the creditor unreasonably delayed, had knowledge, and caused harm to the borrower. So there's lots of ways, including, I've done this, what's called a quiet title action. If a chain of title is defective, or the debt buyer cannot prove ownership of your loan, which see every debt buyer case, a quiet title action can extinguish the lien entirely. I've done this. I'll try to tell you what I did without causing an issue here, but I had clients that may have owned a house and now they lost the house to a big company that's pushed it through a trust, and 10 years later it still shows that the chain of title from major creditor to some weird trust, and then another company shows up and says, you owe us $78,000 now because we own. So you can look at the property records in your county and see that that debt buyer is not there. So I will file a quiet title action. I sue the real owner, and it's a weird sounding trust with a servicer that is probably gone. I don't know. I'm following the rules by following the current owner according to a legal certified state institution county records, and I never hear back. And so then once I've sued and served that weird entity, I then move for default judgment because they never answered the lawsuit and we never hear from them. And I'll send letters to some weird debt buyer, and they, as you know, they'll blow you off. Well, this is a chance where they blow you off to use it. And I'll get people's houses back just by using a quiet title action. So a quiet title action works. So here's what to do if you're facing a zombie debt, and we'll close this now. If you're facing a zombie debt foreclosure, Shazam. Number one, do not acknowledge the debt verbally in writing. Please don't talk. I've done videos on this. Don't talk to a debt buyer. It's never going to help you. Do not say you owe it. If you do talk to them, make sure you say, if you do have to talk to them, this discussion is being done on the purpose of a settlement only. I don't agree I owe anything. I don't know who you are. I'm calling to see what is going on. If you can repeat that 3 times, settlement discussions are not allowed to appear and be used against you under most court rules. Do not ignore anything. You get that letter. It's easy. I've been there, where you want to stick your head in the sand. It's just another debt situation, or emotionally you're like, I don't want to deal with this. This went away 10 years ago. Please, action cures fear. Just step up. Actually, the fear goes away once you do step up. Just trust me on that. Be scared for 5 minutes, then make a move. The first move you make, the toughest move, is the toughest move. And once you make that, you send a letter saying, hey, I don't know this, prove you own it. You will feel better. Please, action cures fear. Take the emotion out of it. Write down everything. Keep a log of all the contacts, because they're going to lie and say, we didn't do that, we didn't say that. And find out if they're in a state that's called a first party state. So if someone's calling you for this weird sound with a weird sounding name and for a debt you know is long gone, you can tape without asking their permission if they're in what's called a first party state, meaning the state, this is in Michigan, one of them, it's you, only you have to grant permission for the recording. If you're in a two-party state, you have to tell them you're taping and ask permission. But again, number 4, keep the emotion out of this, please. So, I want you to run the statute of limitations. Find out when the last payment was made on this loan. By the way, side note, practice note, if you don't know, it's likely they don't know. And I have been in situations, let's put it this way, where things are made up. So, say in your validation letter or whatever letter you send, hey, when was my last payment? And there's ways to find that out that force them to show you, because if they're claiming you owe $80,000 with interest and this, they are required to know that and give it to you under TILA and RESPA, the RESPA letters. So even if you don't know it, they don't know it either, and act on that. Pull the chain of title of the county recorder. As I was talking about quiet title action, that is your friend. They claim they own it, yet they're not on the title history. Send a debt validation letter within 30 days of contact. Send it, please. It causes all sorts of trouble that could make them go away. Send a RESPA letter or qualified written request. Force them to produce the complete payment history. I can't emphasize this enough, my friends. You've watched 700 of my videos on how debt buyers, I've never seen in 30 years, how they can prove exactly what payments were made, why they own it. They can't do it here. They're debt buyers. Check, number 8, check whether you have a 1099-C. If the original lender or prior servicer sent you an RIRS form 1090-C, I got one, so I know I got one, indicating the debt was canceled or charged off, that's powerful evidence against the foreclosure. Consult an FDCPA attorney, a real property attorney, or Parker GPT. Don't spend thousands on an attorney when Parker GPT there is my own thing. Parker GPT is there at a fraction of the cost of an attorney. A TRO, however you go about that, like I told you in the Dow Robertson versus Lanny case, let me just put up the video again, Shazam, that saved the day and stopped the foreclosure on a case and debt that was long gone, and they were still coming after him. So connect the dots, my friends. The Zombie mortgage can be beaten by an FDCPA intersection. So intersect the resurrection, if you will. If it's time barred, the lien assignment is defective, check your county records, the debt was discharged in bankruptcy, or the servicer sent a 1090-C, you are in great shape. Let me just end this way. If you're being chased on a debt 10 or 15 years later, you know by a debt buyer, don't bring emotions. Just go, wait a minute. There's no way, because put it this way, you're the closest thing to that mortgage other than the debt buyer. And if you can't have the paybook and show all these things, and I hope you can for your protection, they can't. You're just one of millions of debts they bought. So don't give up. Don't bring emotion into this. They bought your old second mortgage for almost nothing. So whoever sold it them gave them nothing. That's why it's pennies on the dollar. Please hang in there. Use my letters. Use Killdebt.com. Use Parker GPT. It's the new way to law. Go get these bad guys. Thank you.